Good evening. Welcome and thank you for joining us tonight. My name is Claire, and on behalf of Harvard Bookstore, I'm pleased to introduce this virtual event with Deborah Tuerkheimer presenting her new book, Credible: Why We Doubt Accusers and Protect Abusers. She'll be in conversation with Emily Bazelon. Through virtual events like tonight's, Harvard Bookstore continues to bring authors and their work to our community and our new digital community during these challenging times. Thank you for joining us tonight. In support of our authors and the incredible staff of booksellers at Harvard Bookstore, we sincerely appreciate your support now and always. Every week, we're hosting a slew of virtual events, and our schedule appears on our website at harvard.com/events, where you can also sign up for email newsletter and browse our shelves from home. After the introduction, I will drop a link in the chat to pre-order Deborah's book. It comes out next week. And your purchases and financial contributions, I'll also be sharing a link to donate, make this virtual author series possible, and now more than ever support the future of a landmark independent bookstore. This evening's discussion will conclude with some time for your questions. If you have a question for our speakers at any time during the event tonight, you can go to the Q&A button at the bottom of your screen, and we'll get through as many as time allows. This event also has closed captioning available, and depending on the version of Zoom you're using, you may need to enable the captions yourself by clicking on the closed caption button on your screen. And finally, as you might have experienced over the past 18 months, technical issues might arise. If they do, we will do our best to resolve them quickly, and we thank you for your patience and understanding. Deborah Tuerkheimer is a legal expert and leading authority on sexual violence. She's a professor at Northwestern's Pritzker School of Law, and prior to that, she served as an assistant district attorney in New York, where she specialized in domestic violence and child abuse prosecution. Tonight, she'll be talking to Emily Bazelon, a journalist and legal scholar. Emily's a staff writer at the New York Times, co-host of Slate's Political Gabfest, and lecturer at Yale Law School. You may also be familiar with her best-selling books, Charged and Sticks and Stones. This past week, R. Kelly was convicted, and on its surface, it's a victory for his accusers and even for the Me Too movement. But you can consider his behavior has been an open secret for 20 years, or that even after brave gymnasts went to the FBI, other young women were abused by their team doctor, or any of the half dozen similar cases that have made headlines in the past year or two, well, it starts to look like the odds are stacked against accusers. In her new book, Credible: Why We Doubt Accusers and Protect Abusers, Deborah examines how bias influences the legal system, and in particular, she offers a framework to explain how we perceive credibility, why our perceptions are distorted, and why these distortions can harm survivors. Kirkus calls it a trenchant analysis of how flawed notions about credibility fuel a wide variety of social inequalities, and goes on to say that she cogently argues that until we examine and address deep-seated biases, our society will ensure that we never treat sexual assault survivors with the gravity and care they deserve. The book's analysis is both layered and nuanced, and the language is precise, passionate, and clear. And so now I am very pleased to turn things over to our speakers. And the digital podium is yours, Deborah and Emily. Thank you so much.
Thank you so much for that great introduction. I'm really excited and honored to be talking about this book this evening. I will hold it up, even though I know it's a little backwards for the audience. So I have been in conversation with Deborah for years about the issues in this book. She is one of the thinkers about law and sexual assault and misconduct who I turn to the most, because she's just done foundational work in thinking about some of the deepest flaws in our law and legal system and also how to fix them. And I think this book is a really excellent and yes, trenchant and clear culmination of her thinking to date. And she tends, I think, to be someone who is very careful and thoughtful about a topic that, you know, people have very strong feelings about, but has some really complicated aspects to it. So Deborah, congratulations on your book publication. And I wanted to start by asking you about some of the terms that are really foundational and that you've coined in this realm to talk about some of the problems that you see. So you talk about a credibility discount and then also a credibility boost. And you also talk about a credibility complex in this book. And I wonder if you could start by kind of laying out some of your terms.
Absolutely. I'm happy to do that. I first want to thank Claire and Harvard Bookstore for hosting this difficult but really important conversation. And Emily, thank you for joining me. It's really an honor to talk to you. As you said, we've been in conversation over the years about these issues, and I always love when we manage to connect and muddle through some of these complexities. And I will say too, we're obviously preoccupied with many of the same difficult topics. I highly recommend to anyone who hasn't read the books, Charged and Sticks and Stones, Prosecutors and Bullying, Abusive Conduct, all in the mix. And Emily's work is groundbreaking. So very happy to be here tonight. And yes, let's talk about some of these fundamental terms that I think can help us to better understand what's at stake when someone comes forward with an allegation of abuse. And when I say abuse, I have in mind sexual assault and sexual harassment. So the credibility complex is a cluster of forces that corrupt our judgments around what to believe, and even who to blame and whether to care. The forces that I primarily focus on in the book that I think comprise the credibility complex are culture and law. Those are obviously, big, powerful forces, and they shape us in ways that I think we hardly notice. What we do for the most part is discount the credibility of accusers and inflate the credibility of those who are accused. And I want to say a little bit more about each side of this equation, the credibility discount and the credibility boost. So credibility discounting happens when misconceptions, biases, and reliance on myths about abuse inform our judgments, rather than accurate facts about the world and how it works. And what we see is that when accusers, particularly women who are marginalized and vulnerable, come forward, we're even more likely to discount their credibility and to discount it more steeply than we otherwise would. And on the flip side, when the person accused is a man, a powerful man, a man in a position of authority who's revered and has, let's say, status, then we give even more generous credibility boosts. And the way to make sense of all this, I think I can put it fairly simply, is to say that credibility is meted out along axes of power. And so if you notice structural hierarchies in our society, if you notice power imbalances, if you notice inequalities, then you're likely to be able to predict how credibility is going to be distributed. It falls exactly along those lines.
Yes, so those are very powerful forces. One of the things that you touched on a little bit implicitly is your use of language, and especially gendered language in the book. And you have an author's note in the beginning in which you say that you often refer to victims or survivors of abuse as women and to perpetrators as men because you're following the kind of typical pattern of abuse. And you say that gender is inseparable from sexual violence and its aftermath, and that reality shapes the stories in the book. And I also wanted to give you a chance to talk a little bit about how you use the words victim and survivor, because that comes up a lot.
Thanks. I use them interchangeably in the book, and I gave this a lot of thought, as I think people who write about this topic and speak about this topic do. It's really hard to know kind of which term is precisely the fit, and neither one seems adequate on its own. And so I end up deciding to use both, as many of the survivors and victims I spoke to do. I think the best sentiment that captures why I chose to approach this word choice in the way I did comes from a book by author Donna Freitas. Her memoir is called Consent. And what she says in her book is, I am both a survivor and still a victim. And somehow I will always and forever be both. And I think this really captures this ongoing struggle to heal from abuse, the strength it takes to do so, and the fact that this is, for many people, a non-linear process that's never entirely complete.
So I wanted to ask you about how you thought of the audience for your book, or maybe multiple audiences, and what your goals were in writing it. I mean, you're a law professor, you've written, extremely well-received law review articles. That is a different kind of genre, more specialized, and I wonder why you decided to venture into the realm of a trade book.
I tried to write this book in a way that would be accessible to a lay audience. There are legal terms and there are cases, to be sure, but I explain the concepts in ways that people are sure to understand. And I wanted to reach a wider audience because I feel so strongly that the message of the book is one that people in their daily lives can rely on. And if they do so, if they learn from the book, if they find that it resonates, I do think that this Me Too conversation will be advanced in really important ways. And I guess the one thing I'll add to that, you mentioned multiple audiences. I really did have in mind two as I wrote, and they're overlapping, but each is really important to me. One is survivors. And my hope is that the book resonates with survivors, that the stories in the book are validating, that there's the creation of some sense of solidarity through reading the stories and through the framework that I offer for understanding these experiences of the aftermath of abuse. We focus a lot on abuse itself, but this is really about the aftermath, what happens when someone comes forward or stays silent. And so my hope is that survivors feel seen in these pages. And at the same time, I'm trying to reach responders. And when I say responders, I don't just mean police officers, HR personnel, campus authorities. I also mean friends and parents and coworkers of survivors. And what I hope is that the book helps all of us to respond more fairly and in a manner that's more just when these accusations come our way.
So you started writing about the problems with rape law in particular long before the Me Too movement. And I wonder whether how much you feel that the changes that Me Too has brought about have been able to address those questions. And maybe you could start by describing some of the fundamental problems that you saw when you started out on this topic.
Yes, I have been writing about rape law, particularly the criminal law of rape, for quite some time, and focusing on a few problems. A lingering force requirement in about half the states. And what I mean by that is that non-consensual penetration without more doesn't count as rape or sexual assault still in many jurisdictions. And that's a holdover from a common law tradition that viewed rape as really being a crime against against a man who was the husband or the father of the victim. And the kind of rape that was a problem was akin to what we think of as stranger rape. And so that maintains a hold on our law still today. And we see these force requirements that I think are retrograde and ought to be abolished. I don't think they're consistent with modern understandings of sexual assault as being about the absence of consent. I think that's the gravamen of rape. And I think consent itself is really tricky. About half the states still don't define consent, and those that do often put the burden on the victim to express non-consent. And what that means is that passivity or a failure to do anything qualifies as consent. And I think that's the wrong way to view this. So those are some of the definitional problems that I have been writing about. I also write about the law's treatment of sexual history evidence, and I think that's really problematic. And yet, lurking underneath all of that, I think, are these questions of credibility, and are these questions of which harms matter, which harms count enough so that the law will intervene, and what kinds of evidence bears on the credibility of someone who comes forward and alleges rape. And so all of this is sort of baked into our law. And it really was, I think, for me, it was important to pull back a little bit and ask this fundamental question of credibility and how our law and our culture are shaping our understandings of it.
So, some of the legal flaws that you just described are, as you were saying, they're kind of artifacts of our common law, but it also sounds like they have so far prevailed and endured despite the Me Too movement, which isn't to say that that's the fault of the movement, but shows how calcified law can be and hard to change, I think. I wonder what you see as the main gains of the Me Too movement have been, and how much you have felt like the cultural landscape that you also see as a force has shifted.
I think it's significant. And since October 2017, when this blockbuster reporting on Harvey Weinstein kind of cracked open this wedge, and Me Too stories, so to speak, began pouring out, I think this has really consumed many people who didn't give much thought to abuse in ways that have really lasted. So I will admit that, a few weeks after the Weinstein story broke, my assumption was that this was going to be a fairly short-lived moment. And that has not proven to be the case. I think we're still talking about these issues. More stories are pouring forth. And of course, there's a virtuous cycle here too. When survivors see culture and law responding in new and different ways to these accounts of abuse, I think it makes it more likely that the survivors, the victims, will come forward with these kinds of stories down the road. Because the other side of this is that the credibility complex is silencing. It has a tremendous silencing effect. And for most of our history, the reasons not to come forward, I think, outweighed for most people the reasons to come forward. And I think we're starting to see that shift. And it remains to be seen whether we do the kind of lasting institutional reforms that will seal some of this in.
So, that brings up the R. Kelly conviction this week, which is very much in line with what you're talking about in terms of reinforcing that victims can come forward and actually get what I hope they think is justice. I just want to encourage the audience, before I ask the next question, if you have questions for Deborah, to start typing them into the Q&A. It will actually make it easier for me, because then I can take a peek at them and have something lined up when I'm ready to turn to audience questions. So please, I encourage you to not wait if you have questions. So how do we shift our approach to assessing credibility? In other words, we all actually wield power in this domain, and how we respond to people who tell us about being victims in our own lives, and also how we assess stories that we hear in the news, in our communities. And are there different answers to this question depending on how you're situated? Is it different to be a friend or a therapist or an advocate versus the police, or in my case, a journalist, or a Title IX officer at a university, someone whose job is perhaps to sympathize, but also to check and verify? And I wonder if you have sort of different kinds of advice for people depending on the context and their own relationship with the person telling a story of coming forward as a victim or survivor.
Yes, absolutely. I love this question because it really emphasizes the importance of context in determining really how certain we have to be in order to act. I think that framing is helpful. Belief is not a binary. It's not an on-off switch. It falls along a continuum. Philosophers refer to this as degrees of belief. How sure must we be of a proposition before we act? In the legal system, we have designated levels of certainty before something can be triggered. In criminal court, we need proof beyond a reasonable doubt before a jury can return a verdict of guilty. In the civil context, that standard is lower. Preponderance of the evidence, is it more likely true than not? On campus, there's still that lower standard, and maybe clear and convincing, a different standard. Police officers have other standards, probable cause, reasonable suspicion. And so when we're in legal settings and quasi-legal settings, we have designated levels of certainty, of confidence. And outside of those settings, we don't. And I think it's really important to, as individuals dealing with these allegations in our daily lives, to recognize that those legal standards may be poor fits for our own levels of certainty. Where the stakes are lower for an accused person, I would argue we don't need that proof beyond a reasonable doubt in order to support a family member, a friend, to offer help. And I will also point out that law enforcement officers have a vast array of tools at their disposal to corroborate a claim. They can execute search warrants, they can issue subpoenas. And so gathering that kind of evidence to get to proof beyond a reasonable doubt is at least theoretically possible. Now, officers don't always do that, and that's a problem. But again, outside of those contexts, we just don't have a lot available to us. I would think that journalists are somewhere in between, although obviously, Emily, you are the expert on that. But I think it's helpful to be nuanced in the way that we approach the question of how sure must we be to act. And then the other thing I'll say is that it's not enough just to believe that something happened. In the book, I talk about an allegation of abuse as embodying a trio of claims. So 3 separate claims. When someone comes forward, she is asserting that it happened, that it was wrong, meaning he is to blame and she's not, and that it matters. And if any of those claims fails to move us, if we fail to believe that those claims are true, then we dismiss the allegation. And so the outcome is the same regardless of which mechanism of dismissal is in play.
Yeah, that's a really important set of distinctions. Thank you for that. Later in your book, you write about different kinds of consequences and what they mean to victims and survivors, what they mean to people who are observing, what they mean to perpetrators, and what they mean kind of for society at large. And I was particularly interested in your discussion of apologies and of restorative justice, which is a framework that tries to look for consequences that are meaningful to victims and survivors, as well as serving a kind of punitive function for society. Bringing up the role of apology or restorative justice in the context of sexual assault and even harassment is quite controversial, because often there's a sense that this is a domain in which the legal system needs to be more punitive and has failed at punishment and failed at taking claims seriously, and we can't sort of go soft now before we've even addressed that harm. So I wonder, why you brought in these topics, whether you think they have an important role to play.
Yes. So for me, the connection is to making an allegation matter, to that third claim, that it's important, that it counts. And the question that I asked that led me to write the chapter that includes a discussion of restorative justice is, what does it mean for an allegation to matter? It's obviously a really, really difficult question to answer, and there is not one answer. My choice was to center the stories of survivors and the experiences of survivors, and to recognize that different survivors have very different views of what would make their allegation matter and what would make them feel as if they matter and they count, they're worthy, they're important, they're valued. And so that leads to a discussion of restorative justice, which for some survivors is exactly what is needed. That validation that comes from the acknowledgement on the part of the offender that wrong was done, that he did wrong. There's an apology that is part of this process. And that can be so validating and so vindicating and so essential to healing for many survivors. And I describe a case where it went really well. A girl named Sophia, who was in high school at the time that she was sexually assaulted by a boy also in her high school. They were diverted from the justice system to a restorative justice approach. And it was handled by someone who was very skilled in doing this. Other family members got involved, and she, Sophia, ended up feeling, by all accounts, really empowered by what happened. There was an acknowledgement, and the question of repairing the harm was put front and center to her. And she was able to say what she needed to move on. And at the same time, I talk about a group of girls also in high school at Berkeley High who were offered restorative justice after years of what they felt was the administration of their school not responding to sexual assault effectively. And as you know, one of these high school girls put it, we don't want a feeling circle. We don't want that. We want real consequences. We want meaningful consequences. In her eyes, this was not that. And so I don't think that this is a one size fits all approach. I think that restorative justice can be exactly what a survivor wants, and it can also not be that.
So, in this context, one of the lines in your book that really fascinated me was this idea in talking about consequences, that rather than see the abuser deprived of liberty, victims often want him stripped of what Judith Lewis Herman, another scholar in this field, calls, quote, undeserved honor or status. And then you say that Herman's study of victims shows that most who turn to the legal system were motivated by a wish to publicly expose the offender, not to cause him needless humiliation, but to divest him of undeserved respect and privilege. And that there's a way in which you go on to talk about how victims hope their own standing in their families and communities would then be elevated relative to the abuser. And I wonder how this fits into this question of criminal punishment, expulsion from school in the context of universities or secondary school, and whether sometimes the stripping of liberty is how you strip someone of their undeserved status, or whether you think of those as separate things.
I think that it can be exactly that. The stripping of liberty can be aimed at restoring the balance of power. I came to Judith Lewis Herman's work really after hearing over and over again from victims that punishment to them was often important, but not for the reasons that we would often assume. And it wasn't about inflicting pain for pain's sake. It wasn't about cruelty. It was sometimes about protection. It was sometimes a sense that other potential victims would be harmed if this individual wasn't treated in a certain way. And maybe that was incarceration, and maybe it was suspension or expulsion from school, but protection was really important. But so was this sense that community condemnation, and in whatever form that took, would be one way to restore the degradation and the disempowerment that the sexual abuse represented to this person. And so the research that Dr. Herman has done, I think, was very much aligned with what I was hearing, and with what legal theorists sometimes call the expressive theory of punishment, which is to say that the message communicated by punishment is one way to understand why it can be really important. And again, not to be cruel and not to be unnecessarily barbaric, nothing like that, but rather to somehow express the community's sense that a power imbalance needs to be righted in some way.
Thank you for that. So let's turn to the audience questions, which are coming in and look really interesting. One person is asking, do you think the belief that we must conceal the identities of victims perpetuates the view of sexual assault as a shameful event compared to other victimization experiences? So, for the press, we will often mask the identities of sexual assault and rape victims in a way that we would not do for someone who had their purse snatched or was the victim of, even a homicide. And that, what do you make of that distinction? Does it have this shaming quality, or is it performing a different kind of social function?
Yeah, I think that this is a problem of transition, meaning that absolutely sort of sex crimes exceptionalism is something that I would hope would move away from, and that there would be a time where the shame on self-blame associated with sexual assault and harassment was no longer so prevalent, but we're not there yet. And so in the interim, I think it would be unfair to put the burden on victim survivors, the burden of living in a society where still this kind of blame is heaped upon them.
Your work, new question from someone else. Your work has focused on sexual violence for most of your career. What inspired you?
Well, I've been, I think, thinking about and working with these cases since I became a lawyer. My time as a prosecutor was very much shaped by the cases that we would now think of as special victims cases. It's why I wanted to be a prosecutor, and it's why I wanted to become a law professor. I wanted to continue to write about these issues and be able to have the luxury of thinking deeply about how our system fails to respond to violence against some of the most vulnerable populations. And I also wanted to be able to teach my students with with this orientation in mind, with the idea that these are very important issues, hugely complex issues. And so I think in some ways, this has just driven my entire professional life.
Is there a story or example in your book that shows the kind of problem of a credibility discount that you're describing, and that also might, perhaps that in its actual reality, or maybe in some alternate imagined path, that shows how we could rectify this credibility discount for someone who's marginalized or someone who's accusing someone of a lot of status?
Yes, I mean, just to sort of explain to the audience how the book is structured. Each of the chapters really begin by highlighting a story of someone who you're probably not familiar with. And so the book definitely talks about well-known cases and looks at these cases through the prism of the credibility complex. And so there is Weinstein and Nassar and Epstein and Cosby and R. Kelly. But I really do try to amplify the voices of people whose cases don't make the headlines. And so the chapters really begin with those stories. And each of those stories, these dimensions overlap, right? And so what happened, who to blame, and whether to care, these are not as cleanly divided as we might think. But those chapters are each about the credibility discount and credibility inflation. And so the stories are going to focus on that particular dynamic. So for instance, there's a story about a woman named Aja Newman, who she was a baggage handler at LaGuardia Airport, a Black woman who was experiencing extreme shoulder pain and went into the emergency room at Harlem Hospital She was given some morphine for the pain. And then it turns out she was also given an unauthorized injection of a drug that really knocked her out. And she was sort of only vaguely aware of the doctor who had given her this drug masturbating while he sexually abused her. And when she sort of came to, she had the wherewithal to realize that coming forward against this doctor, she would never be believed, never, ever be believed. So she took the sheets from the hospital as she left, and she gathered the evidence that she knew she would need in order to persuade anyone. And still, it took a while for this doctor to be arrested. She was called a prostitute. She was called a drug addict. She was called a liar. And it frankly took other women who had also experienced this kind of abuse in the emergency room in order to trigger an arrest and a prosecution. So, I mean, I think that this is an example of the credibility discount at work. It focuses on distrust, on just the failure to even believe that this happened, but maybe also to care that this happened to her. And she's very frank about the fact that being a woman, being Black, being poor, and coming forward against a white doctor, she knew that she was going to have to harness every bit of corroborative evidence possible in order to get anyone to do anything.
That's such a powerful story. And it also, I think, points to a dilemma that you discuss in the book, which is that in some ways, we've become accustomed in stories like Weinstein or Epstein or Cosby or R. Kelly to expecting multiple victims to come forward. That's kind of a way, I think, that culturally and legally that there's a sort of power in numbers and a sense of reassurance that all of these people can't be lying. And yet there are going to obviously be instances in which there are not multiple victims to come forward and there's still harm to be rectified. And I wonder how you think about those sort of competing aspects of this issue.
Yes, I worry about the lone accuser. I worry about the first accuser. There is, as you say, power in numbers, credibility in numbers, right? And because credibility is a form of power, we're saying just the same thing when we say those things. Again, maybe another problem of transition. I would like to think that we're starting to see the system respond to these cases, albeit cases with multiple accusers. But the hope is that our thinking, our collective thinking starts to change, starts to evolve, starts to incorporate better understandings of how victims behave, who these abusers are, right? They're not monsters, they're people in our midst. And these myths of monster abusers and perfect victims cloud our thinking. Maybe these myths start to dissipate when we see these cases resolve themselves in very public ways.
What makes you hopeful? Are there statutes that are changing, rulings from judges that seem to be addressing some of the harms and flaws we've talked about? Is it the staying power of Me Too itself? Talk a little bit about what you're watching that makes you optimistic.
It's definitely the staying power of Me Too. This conversation is ongoing. It's not dying out. It's not petering out. It is front burner, and I think it will be that way for the foreseeable future. That's really good. There have been some laws that have changed. More workers protected by statutes that prohibit discrimination in the workforce. And I think that's really important. Extension of time limits for reporting abuse, both in the civil domain and in the criminal context. Some judicial rulings that seem to be recognizing the realities of abuse in ways that I think we wouldn't have seen 5-10 years ago. And so all of this gives me reason for hope.
This is a question from Lauren Layden-Hardy, who's saying hello to you. And she asks whether your research has led you to some advice for victims who are thinking of coming forward today, given that so many of the practices and standards that reinforce problematic credibility distributions continue to shape the institutions that are supposed to be facilitating coming forward. And so Lauren is asking whether in this context of what remains an unjust system, there are stories you heard or cases you studied where you thought, that was smart. It was smart that she did or said that. And the kinds of details, maybe like gathering the sheets that you just mentioned that helped people gain the kind of credibility that you think they deserve.
Lauren Layden Hardy is a fabulous philosopher teaching at Amherst, and she was really helpful in informing my thinking, and she's quoted in the book several times. So thank you, Lauren, and thank you for your question. I've been asked this question of advice, and I'm really careful not to suggest that coming forward is necessarily the right decision for every survivor. I really want to sort of honor the fact that keeping quiet about the abuse for some time can be the right decision. This credibility complex is powerful, and being dismissed can be devastating. I've heard over and over again that it can be even worse than the abuse itself. And I think that's one message from the book that I'm hoping people will take on board, this idea that how we wield our power to judge credibility has these enormous impacts. So when someone comes forward, which I think is really where your question was pointing, I do think that choosing very carefully who you report to, those first disclosures are often to someone who's trusted. And it doesn't always go well because that person is trusted, but I think that can be really important. And look, the burden should be on the person doing the interview, if we're talking about an official, to be trauma informed and to conduct that interview in a trauma informed way. But sadly, what I've heard from many survivors is that they had really to think through how they were going to provide their narrative, how they were going to shape their narrative, recognizing that the questions weren't going to be informed by the realities of trauma. And so to have to do that upfront, thinking through what the account, how to put the account together in a linear fashion, which is what people expect, even though that expectation is unreasonable. I hate to say that's my advice, because I want to emphasize it should not be a burden that is the victims to do this work of providing a neat narrative that kind of fits into the expectations, and yet that has often seemed to really help get uptake from the person responding.
I'm gonna jump in here for better or worse. I think sometimes for journalists, one thing that's been changing, I think in a helpful way, is if you have told someone in the moment or around the time that the abuse happened, and then you can call on them as a kind of backup witness to what happened. That's something that journalists are now paying a lot of attention to. And it can be outside of any kind of formal reporting system. But I think we saw this, we've seen it in some of the reporting about campus sexual assault, and then we saw it with some of the accusers against President Trump when he was in office or before he was in office. And I think it's becoming part of how journalists assess how to tell these stories. And it's a different kind of coming forward, since it can be someone you trust and who loves you and wants to support you. Question from Heidi Kummer. Do you think the issue of power differential is taken into account enough? Is there a difference in how accusations of harassment between peers versus, say, teachers and students are approached?
I do not think that this question of power is adequately addressed in culture or in law. I tend to think that everywhere we look, we ought to be attending to power differentials, and we generally don't do that. I'll give just one example. Sexual harassment law really asks the question of whether the harassment, the harassing conduct, was unwelcome. And again, puts the burden on the victim of workplace harassment, such as it were, to demonstrate unwelcomeness, which is really behaviorally unreasonable and absolutely does not account for power differentials. So, that's a place where you can sort of see the law baking in this notion that if you don't do enough to prevent your abuse, you're at fault.
That's really interesting. The next question is about students, which is useful for me because I want to ask you some Title IX related questions. Title IX is the statute that has opened the door to a lot of efforts to address sexual assault and harassment claims within the context of schools and universities as part of gender equality, which is what Title IX is about. So this question, and it's sort of broad, but do you recommend that a student who's been abused go straight to the police or work within the school's internal system?
It's so hard for me to answer that because I've heard stories that point in both directions. I've heard stories of victims coming forward to their Title IX officers and finding that they're getting support on validation on that front, but that the local police handled the case very, very poorly. And frankly, I've heard the opposite. I've heard vice versa. So, this is, I think, very dependent on who the actors are in a particular jurisdiction. And I wish it weren't that way. Of course, I wish that everyone responded fairly to these accusations, but I don't think I can generalize as between the Title IX apparatus and local law enforcement.
So some of the initial energy kind of pre the reporting about Weinstein for reform really, I think, came from universities and came from this Title IX context. And as you mentioned earlier, at some schools, you have this standard of a preponderance of the evidence that it's just more likely than not that someone be found what schools call responsible and then face disciplinary consequences for sexual assault or harassment. I know you've thought a lot, and we've talked a lot in the past about sexual assault allegations on campus that can be, they can take place in a context where they're quite difficult to confirm. Sometimes perpetrators in particular have been drinking. That's a pattern that we see. Sometimes that's true of survivors and victims. And I think there's been a really interesting and quite fraught conversation about balancing the rights of the defendant, the rights of someone who's been accused, versus making sure that victims feel like they can safely come forward. And in the campus system, there tend to be fewer procedural protections, but on the other hand, there are still important consequences if you think of suspension and particularly expulsion for people who are found responsible. And I've found that I'm having a really hard time kind of assessing whether the pendulum has swung too far in the campus context, whether there are problems of race discrimination where Black students may be accused of assault more, and often unfairly. And I wonder sort of what your take on this set of questions is at this point, or if you feel like it's also very context dependent, which is often my own default, depending on what school you're talking about.
I like that default. I think I'm gonna also embrace it. But I will echo your pendulum swinging point and say that, the change in administrations, I think, has really complicated efforts on the part of even well-intentioned administrators to get a handle on how to implement these procedures in ways that are fair and consistent with the educational mission. And I have had conversations with people who I think are genuinely trying to get it right. And the guidance coming from the Obama administration and the Trump administration and now the Biden administration is just buffeting them in all sorts of directions. So I think it's really difficult. And I also don't want to pretend that everyone is trying to get it right. And I think there still is, on many campuses, certainly not all and probably not most, an impulse to push some of this under the rug. I don't think that we've kind of moved past that. And so it will be really interesting to see what the Biden administration does with these Title IX rules and whether there can be some settling into a mode where these rules can be operationalized in ways that are fair. We'll see.
So one thing that distinguishes many really probably all university systems from the criminal justice system is the level of secrecy about what's happening. Once you're in a kind of formal adjudication process, it remains behind closed doors, and there may be some reporting about the outcome, but it tends to be very sparse, and we don't get a lot of details. We don't have public hearings. There are ways in which that I think can benefit victims and survivors because they're able to more privately divulge what's happened to them. And there can also be benefits for perpetrators in that everyone doesn't know necessarily the details of what transpired. But is the secrecy a problem for society at large? Because it's part of why you and I are both kind of stumped about how the system is actually operating.
Yes, and I think similar to the answer about keeping victims' names out of the press and kind of retaining some level of confidentiality around that, I think that we're in this kind of mucky gray zone where hopefully we improve the system's response to sexual assault on campus. But until that happens, I do think that these are, close-knit communities where there is so much stigma attached to making an allegation of abuse. I, tell stories in the book of women who came forward and were just pilloried, right? And the experience of being known as the person who made this allegation, again, I think was just so traumatic, so deeply wounding that many of these survivors would, I think, say they wish they had not come forward at all.
So this is another question from the audience. Do you think the credibility burden you describe too often results in decisions to prosecute only the quote winnable cases? Would the criminal justice system and society benefit from more less than perfect cases being brought forth?
Yeah, this is such an interesting question. Prosecutors, of course, have an obligation to only bring forward cases that can be proven beyond a reasonable doubt and where they believe that this is a person who ought to be prosecuted. There are all sorts of ethical constraints that I just want to acknowledge. And I think that the idea of winning a case and that kind of winnability standard really prevails in sexual violence cases. And because what's interesting is that because prosecutors can point to potential juries as being the problem, right? It becomes easier to say, I can't bring this case forward. And some of the victims in the book that I spoke to describe these interactions with prosecutors that were infuriating to them, where a prosecutor, one in particular that I'm thinking about, where a prosecutor said to someone who had come forward with an allegation of rape against someone who she said assaulted her at a fraternity party. And the prosecutor said, "You're only one victim. I had a case like this that I lost last time around. He was a college boy like this defendant, and it was a not guilty verdict. And so I can't go forward, and I'm going to offer him what in the view of this survivor, and I can completely understand why, was just too sweet a deal. It was a disposition that raised eyebrows of those who were watching. And the prosecutor said, "It's not me, I believe you, but I can't convince 12 people beyond a reasonable doubt."
So in other words, perhaps overlearning the lesson of one case.
Yes. And, and I think the question, raises this larger issue of if juries are unfairly, are acquitting for reasons that have to do with discounting credibility and bias and a sense of protecting particularly certain kinds of men who seem to have a very bright future, right? If that's what's at play, then what is the role of the prosecutor in bringing these cases forward, notwithstanding that, and letting, if the survivor wants to testify, letting that case go forward.
So let me ask you one last question, since we're getting close to the end of our hour. So if you could look ahead 10 years and you also could wave a magic wand, what are the kind of systemic changes that you would make? And are they within the, are they amenable to waving a magic wand, or do they take kind of a whole sort of cultural shift? In other words, can you change a few laws, change some rules, or do you really need kind of the force of the whole community behind you to make the kinds of changes you think that we need?
I've become convinced that legal reform and cultural change really go hand in hand, and they have to. And so I think we're going to see in fits and starts cultural transformation around this question of credibility, along with changes to the laws that bake in the credibility discount. At least that's my hope. If I wave my magic wand, I have both kind of happen in tandem, and I have people individually making better assessments in their daily lives about credibility, and I have people working on those laws and those institutions so that these changes are lasting and enduring. And I think that, that's how this has to work, culture and law moving forward together.
That seems like a great note to end on. I think Claire might be reappearing in a moment or two to take us out.
Hi, everyone. Thank you so much for that wonderful conversation, Deborah and Emily. It was really interesting. And as I said to Deborah before, maybe not like a fun conversation, but one that was like really like smart and fascinating and gave us all something to think about. So thank you both. And thank you to everyone out there for spending your night with us. You can learn more about Deborah's book and pre-order it on our website at harvard.com or via the link in the chat. And on behalf of Harvard Bookstore in Cambridge, Massachusetts, have a great night, keep reading, and please be well, everyone.
Thank you so much.
Thank you, everyone.